Hello, everyone, and welcome to Uncivil Law. In today's case, we have a sovereign citizen getting smacked down by the district court. This is an ongoing case in the case of the United States of America versus Michael Williams. In this case, Mr. Williams is being charged with being in possession of a firearm by a prohibited person. And the criminal trial is ongoing, and he's filed various motions and various requests. But he's a sovereign citizen. And so the district court has to explain to him in small, easy to understand words that no, none of these things. So, yes, we get to see a sovereign citizen get smacked down once again. So we get to enjoy this joy. So let us all appreciate the world that is Michael Williams and his wonderful contribution to the law. Let's get started with this. The defendant was indicted with one count of possession of a firearm by a prohibited person in violation of federal law on May the 8th, 2019. Stephen Harris was appointed to represent him on May the 13th, 2019. At the May 30th, 2019 arraignment, defendant refused to plead, and the undersigned entered a not guilty plea pursuant to law. So, you know you're off to a promising start. The defendant has refused to plead guilty or not guilty. I'm not going to answer your question. So the court says, fine, I'll enter a plea of not guilty because that is the baseline thing. So if you don't want to enter a plea, I'll enter one for you. Yeah, not guilty, no problem. Yeah, so we're off to a promising start. During the arraignment, the defendant began to espouse some of the misapprehensions, which are hallmarks of sovereign citizens. Well, we kind of knew that was already happening. Yeah, we've refused to plead, and now he's going to start speaking some sovereign citizen nonsense. Now the court says, what did I do to deserve this? Yeah. For example, he challenged the jurisdiction of the court and made references to both civil common law and admiralty law. Yeah, the law of the seas, because somehow that's relevant. Despite the defendant's recalcitrance to plead or acknowledging the jurisdiction of the court granted the defendant 30 days to file pretrial motions. So we are trying to be nice to you. So despite the fact that you refuse to grant our authority or anything like that, we'll give you 30 days for your motions. So you can file your motions and we'll consider them. So yeah, we're trying to give you process, man. You don't want process, but we're going to try to give it to you anyway. Also at the hearing, defendant indicated a desire to proceed pro se, because of course he does. He wants to go this alone. That sounds like a good idea. And that hearing was scheduled for June the 6th, 2019. So he said, I'd like to proceed pro se. And the court is going to inquire, are you sure? Are you really, really sure? Really? Are you really sure? So we're going to schedule a time to determine whether or not you can go pro se and whether or not you have any idea what you're actually asking for. So we'll schedule a hearing for that, yeah. However, before the hearing could occur, on June the 2nd, 2019, defendant's counsel filed a motion requesting a psychiatric exam. So this guy's defense lawyer is saying 4 days before the hearing, yeah, I think my client might be insane. I think he might actually be insane. And so I want you to order a psychiatric exam. And this is you've appointed me to represent him. And he may not be fit to represent himself. We didn't have clues. And I'd like you to give me a psych exam, please, so we can determine whether or not this guy is competent. That'd be great. Yeah. So his own defense lawyer is trying to save him in spite of himself. That's good news. That motion was granted on June the 4th, 2019, because of course it was. And defendant was ordered examined and observed pending a report on competency. As a result, the inquiry into desire to proceed pro se was deferred. So yes, we were going to have a hearing on the pro se motion. But 4 days in advance, the defense lawyer said, yeah, can I get a psychiatric report, please? And the court's like, yes, you can. And we'll defer the pro se motion because we're not sure that he's competent to represent himself or act as his own lawyer, which are technically different questions. But we're not sure about either one. So yes, we'll give you your psych exam first. That's good news. The court received the psychiatric report on August the 8th, 2019, and held a hearing on September 11th, 2019. At that hearing, the court inquired of the defendant whether he wanted to proceed without counsel, and defendant declined to invoke that right. So there's a hearing on this issue and said, for the purposes of this hearing, do you want to go it alone? And said, no, I'll take a lawyer. That's good. So on October the 7th, 2019, the undersigned entered a report and recommendation finding defendant competent to stand trial. Competent to stand trial is pretty low bar. So you just really have to understand the charges against you, like what they are and what your potential punishments are, and be able to assist your lawyer. It's a pretty low bar. So even your sovereign citizen can clear it usually. Yeah. After no objections were filed, the report and recommendation was adopted by the district judge. On January the 15th, 2020, the defendant filed 2 motions at issue, as well as a motion for bond. The court set a hearing on those motions for January the 30th. On the morning of the hearing, the undersigned became aware of a handwritten letter in which the defendant had submitted to the court, in which he suggested he might wish to be pro se in that matter. So he's like, no, happens, I want to be pro se on this issue again. I was smart enough to recognize I needed a lawyer before, but now I think I can go it alone. Now I'm ready to face the government. Sure you are. At the hearing, after extensive questioning, the defendant refused to unambiguously invoke his right to proceed without counsel, and the court proceeded to hear argument from the appointed counsel. So yeah, there was a handwritten letter in which you said you wanted to do a pro se. So the court is going to ask you some questions to make sure that you understand what you're asking for and make sure you understand what it is, and do the sort of colloquy. And one of the things the court asks you is, do you want to proceed pro se? And I say, I refuse to answer the question because I refuse to recognize your authority. Wait a second, do you want to proceed pro se or not? I don't want to tell you because I don't recognize your authority. Okay, well, you have the right to waive counsel if you want. I just need to make sure that you actually understand what you're doing and stuff like that. So can I ask you some questions? No, you can't. So there was an extensive attempt to get him to say whether or not he wanted a lawyer or not, but apparently he wouldn't even answer that question because to do so would admit that the charges are legitimate or something. So the court's like, well, if you have a right to a lawyer, you have a right to a lawyer. So if you're not going to waive that right, then I guess your lawyer is still your lawyer because you won't actually waive your right. Okay, so your lawyer is still your lawyer because you won't actually say, yes, I want to represent myself. You gotta love this guy, man. Despite the extensive nature of all these attempts, the defendant again filed a letter requesting to move without assigned counsel. So you keep sending letters, and then every time we have to have a hearing in which we want to make sure that you actually understand that you refuse to answer our questions, and you keep doing this despite this extensive effort. It's like, just tell us what you want, and we need to make sure that you understand what you're asking for. So, you actually need to answer your questions, but we're going to keep trying by doing letters, I guess. I don't know. At the second hearing in as many weeks, the court again inquired as to your decision to proceed pro se. So we're going to try this again. Finally, after extensive questioning made no easier by the defendant's desire to talk over the court and complain repeatedly about all aspects of the prosecution, so the court is trying to ask you the required questions, and you just keep interrupting the court and trying to talk about other things. I'm like, I don't want to really, I just trying to figure out something this issue. Can we talk about the relevant subject? No, we can't. We got to talk about our stuff. Okay. Yeah. So after this rigmarole, the court determined defendant had made the request unambiguous and made the required showing under Ferrata to proceed pro se. So even though you fought me every step of the way and basically were trying to make my life as difficult as possible, I have figured out finally that yes, you really do want to proceed pro se, and that we've made the required showing under the Ferrata to make the required hearing. So they actually called a Ferrata hearing for this purpose. So yes, you've met all the standards. So sure, you can proceed pro se. So good luck with that effort, I guess. Thus, the court relieved defendant's assigned counsel, appointed said counsel as standby counsel, and allowed defendant to proceed on his own behalf. So this is very typical too. So when you represent yourself, it is very typical for the court to give whatever counsel you had and put them in standby status. So if you prove to be disruptive or you need legal advice or whatever, so we'll give you a lawyer who's there to advise you and is in a position to take over if you decide to completely try to derail the proceedings. At the pretrial conference scheduled on February the 14th, the court granted defendant a brief continuance to allow defendant to prepare in light of his pro se status. So yes, we are going to give you a bit of more time to prepare because you have no idea what you're doing, but we'll give you a bit more time in the hope that you'll figure out what you're doing so that you can proceed. Very typical as well. Defendant has filed a series of motions for the reasons discussed below. They are dismissed or they should be denied. So yeah, we've got a whole bunch of motions that are pending by this pro se. Having finally determined that he's pro se, apparently, we've got a whole bunch of motions, and we're going to deny the motions. So in order to figure out whether or not the motions should be granted, we probably should start with the motions. So let's start with the motions and look at what he actually asked for. And let's use our best legal minds and determine whether or not this is a legally competent request. I, the above herein mentioned, and hereinafter mentioned, flesh and bloodman, Michael Levant Williams, Michael Williams, known also in the commercial registry as Michael Levant Williams, Michael Williams, number 6780469, AEO, Ancient Egyptian Order Lodge number 9, ENS Legis of United Nations of the Yamasee, Wachita Creek, Seminole, Muskogee, Indigenous Aborigine Natives, a government of retained sovereigns, United Nations number 0208-1992 125-119, Bureau of Indian Affairs number 0208-1993 215-199, doing business as, he has to say it twice, as the misnomer 2019-08621, parentheses, 550-22174, end parentheses, Michael Levant Williams, date of birth redacted, social security account number redacted, ens legis of the United Nuputuan Nation, attest as Sir Juris under penalty of perjury that the following is true. So begins one of the defendant's motions with this court. Okay, well, I would humbly suggest this is not the greatest legal memo I've ever seen in my life. It's not the most legally competent thing I've ever read. It's a way to begin a motion, I guess. Good. Thanks. All right. Unfortunately, the defendant doesn't stop there. Of course he doesn't, because that would, be nice. Almost every motion he's filed with this court since being granted leave to proceed pro se is peppered with references that he's a sovereign citizen. Well, apparently he's a citizen of the Yamasee, Wachita, Seminole, Muskogee, and some other things too. But yeah. So here are some of the things that the defendant has said and other things. See, for example, this document in which the defendant said, quote, any evidence, facts, not allegations, opinion, alleged defendant is subject to the constitutions and laws of the plaintiff, state of Georgia, just because alleged defendant is physically in Georgia. Another document, another quote from the defendant. Not in any real sense adversary. If it were a true adversary against an alleged defendant, it would be laughable, since to even try to discuss causation, because defendant is not accused of causing anything real or imagined. There is no adversary, alleged plaintiff, a fiction at best, ostensibly acting through Brendan Sheehan, badge number 63325. That's not a badge number. That might be his attorney number. That's not a badge number, but... And Joshua Ash Bearden, United States Attorney for the government, who has not alleged the violation of legal right. The complaint is unfit for adjudication. Further quoting from the defendant. Now comes Michael Williams, alleged defendant, by special appearance and only participating under threat of duress and coercion, not submitting to the cited I love the random capitalization, by the way. Just throwing some random capitals for no reason. It's not submitting to the cited jurisdiction over me, who submits to this motion in limine to prevent prosecution from making arguments outside the facts. I'm not sure why we have random capitalization for no reason. I'm not sure why these things are capitalized. This is great. Judge Carnes, while she was sitting as a judge for the Northern District of Georgia, summed up the problem with the sovereign citizen mumbo jumbo in 2013. Yeah, so we have a judge who has previously had to deal with sovereign citizens in the past, and has summed up, here's the problem with sovereign citizens. Like, we need someone to describe it, but at least we have someone telling us. So what is the problem with sovereign citizens? I'm so glad you asked. Let's figure it out. This strategy, based on defendant's claim to be a sovereign citizen, serves to delay proceedings, create unnecessary work for court and counsel, and distract the court from adjudication on the case of the merits. At bottom, defendant pursuing a sovereign citizen strategy claims a federal court has no jurisdiction to try him for federal crimes on which he's been charged. The defendant purports to rely heavily on the Uniform Commercial Code, admiralty law, and other commercial statutes to argue that because he's made no contract with the court or the prosecutor, neither entity can foist any agreement upon him. The criminal code is apparently not one of the groups of statutes whose validity the defendant will acknowledge. Accordingly, the defendant contends that he cannot be found guilty of any of the criminal laws because, of course, they don't exist. The sovereign citizen defendant typically files a lot of rambling, verbose motions, you don't say, and in court proceedings will often refuse to respond coherently to even the simplest question posed by a court. Each question the judge is volleyed back with a question as to what the judges claim and by what authority the judge is even asking the question. When referred to as defendant or by his name, the defendant will frequently indicate there's no proof he is the defendant, but he's instead a third-party intervener. In proceedings, the observant sovereign citizen defendant clings doggedly to the sovereign citizen script, with the record in this case reveals to be tedious and mind-numbingly repetitious. Any colloquy with the court is usually characterized by frequent interruptions by the defendant, who attempts to talk over the judge. For the most part, the defendant's statements to the court are gibberish. On the matter of legal representation, the defendant will often refuse to cooperate with, or even speak to, his court-appointed counsel, and will sometimes protest he never authorized the appointment of counsel. Yet, when the court attempts to engage the defendant to determine whether the latter wants new counsel, or wants to represent himself, so we're not happy with our counsel because we didn't hire him. Okay, does that mean you want different counsel to represent yourself? So let's ask the next logical question, right? The non-responsive dialogue begins with defendant refusing to affirmatively indicate his waiver of counsel or answer in a coherent way about how he wishes to proceed. So I'm not happy with this lawyer that I didn't hire. Who the heck is this guy? Does that mean you want a different lawyer or you want to represent yourself? I refuse to answer your questions. What is your authority over me? To that end, the defendant's submitted letter of credit is patently frivolous mumbo-jumbo. Defendant's motion in limine likewise argues the court lacks jurisdiction over him because the Constitution and the laws of the plaintiff of the United States are not applicable to him. To the extent these motions are even comprehensible, which they're not, they bear all the hallmarks of sovereign citizen theory and therefore are dismissed as frivolous. So no, none of these things. Defendant has also filed a motion to strike and dismiss the complaint. Defendant's motion can be broken down into two general complaints. First, defendant, again, generally contests jurisdiction of this court over him and alleges there's been no offense committed, which is injurious not only to the victim but the public at large. Among his other complaints, defendant alleges the government has to prove a corpus delicti beyond reasonable doubt. And that's when a judge hears the phrase corpus delicti, it's all over, man. It's all over. Corpus delicti is essentially like who the victim is, but it's one of those sovereign citizen buzzwords. I can't imagine a scenario where, as a lawyer, would ever use the phrase corpus delicti in any proceeding ever. I can't imagine it. It's a legal concept, but there's no occasion where I can really imagine a lawyer using it. So if someone is using it in court, this is about the time the judge puts their head in their palm of their hands and says, "What am I doing here? What has my life become?" It's one of those things we're off to. We're in Neverland. For the foregoing reasons, the motion for discovery is dismissed as moot. The motion in limine is denied as frivolous, and all their motions are denied. So that is the end of the case. Well, no, it's really not because it's still ongoing, but it's at least the end of our coverage of the case of United States of America versus Michael Williams. In this case, Mr. Williams is being tried for possessing a firearm by a prohibited person. So it suggests it's not his first run-in with the law, but he's come up with a new legal strategy. His legal strategy is, I'm going to say sovereign citizen things and hope it gets better. It doesn't. It doesn't get better. You can't just make up stuff. There are actual rules that actually apply and stuff like that. So, that's not going to work. And so, that's the end of the coverage of this case.